I call the whistle.
Te mangai o te whare. Thank you for the opportunity to speak on this committee stage debate of the Judicature Modernisation Bill, and I'd like to congratulate the Minister and the Select Committee, because this is probably the biggest bill that I've ever seen come through the House. And although I am now on the Justice and Electoral Select Committee, I've played no part in coming to this point in the process, but I want to acknowledge those who have been throughout this this piece of legislation, and my contribution really at this point in proceedings is to talk about my supplementary order paper. I'm not quite sure whether or not it fits, but hopefully we'll be able to figure out where it's best in terms of inclusion in this piece of legislation. So I was motivated to write this supplementary order paper because the Judicature Modernisation Bill is about, and I'll go to the purpose, it's about consolidating into a single statute the provisions of the Judicature Act 1908 and the Supreme Court Act of 2003. And under B3, it's about judicial and other officers, including their selection and appointment and conditions. So I really want to focus on that, and particularly in terms of the Māori Land Court, because currently Māori Land Court judges are appointed under Section 7 of the Te Ture Whenua Māori Act 1993, and so the Governor-General by warrant appoints fit and proper persons. No reference is made as to who advises the Governor-General to the appointment in that piece of legislation. And so from our perspective as a Labour Party, the fit and proper person, actually that is fundamental to what my SOP is trying to address, because we believe that the person who can determine who is a fit and proper person to be a Māori Land Court judge actually is the Minister of Māori Development. And I've included in my supplementary order paper that, and I'll read it out, to apply the generic provisions of the appointment of judges, which is set out in this bill, would result in a failure to recognise the distinctive nature of the relationship between Māori land, Māori landowners, the Māori Land Court and the Minister of Māori Development. So essentially we're trying to preserve a convention that has been operating in statute. And we all know that convention is overridden by statute, and so this seemed an opportune time to deal with this particular issue. I think the other point I wanted to make is that, yes, I realise advisors is hugely specific, because essentially what it does say is that the Minister of Māori Development will select the Māori Land Court judges. I was also motivated to bring this piece of legislation to the House because I think there have been concerns from some of the submitters and some Māori Land Court judges, and I have had some feedback from one of the Māori Land Court judges. And I was trying to figure out whether this SOP fits in this part of the legislation, because the heading, Part 2, is District Court, and Subpart 2 is about judges, and then 192 is about the appointment of judges. So there seems to be a need for clarity about whether this is the appropriate place in this bill for the supplementary order paper to fit. And it all then stems from whether or not Māori Land Court judges hold district court warrants. And so I went on to the Justice website, and it's interesting, under the title courts, it's got jury service, going to court, civil, criminal, and then it talks about all the different branches, I thought, of district court warrants, which are youth courts, family courts, coroner's court, employment courts, environment courts, and included in that is the Māori Land Court. So there does need to be a determination from the officials, and if I'm wrong, I'm wrong. But so what I've thought is that there's another part in this legislation, which is Section 568. And Section 568 is about, references the amendment to the Te Ture Whenua Māori Act of 1993. And so I'm looking at another SOP then that will amend this particular part of the section I haven't quite figured out where we're going to put it, but the convention that we want to put into statute, Mr Chair, thank you, Mr Chair, in my SOP will now fit into here. And I want to thank the Minister, actually, for taking the time to converse with me this morning and to highlight that we've possibly got things wrong after netball training. Because if that's the case, then I'll withdraw the SOP that's on the table and I'll put to the House another SOP. And I'm really happy to do that. But what I hope is that behind my intentions, people will see that what I am trying to do is actually about the mana of the role of the Minister of Māori Development and the mana of the role of our Māori Land Court judges. And so I did ring, or Nanaia Mahuta did actually on my behalf, Judge Karen Fox this morning to ask about her warrant. But her particular warrant is for the Māori Land Court and the Environment Court. And I think that having a convention written in statute, given the opportunity that this bill presents, because we are modernising the Judicature Modernisation Bill, to put into statute a convention that seems to be long running, everybody's committed to it. So I just don't understand why, possibly, that there'd be any problem with it. I'd also like to thank my colleagues from across the House, because I did this very quickly. And I talked to Dennis O'Rourke in the House last night, and I know New Zealand First are supporting my supplementary order paper. I also emailed it to David Clendon, and I want to thank him because he indicated that the Greens are going to support my supplementary order paper. Because at the end of the day, I think that we all agree that principle of the Minister of Māori Development appointing the Māori Land Court judges is incredibly important. And so if there is an opportunity for that convention to now be part of statute so that everybody knows and it's transparent, then I actually think that is a positive development. And I just want to say this is no slight to anybody. I know that, the generic aspects of this piece of legislation, and again, I kind of intimated that the Attorney-General by default actually has a lot of power in this process, because they will be determining who they advise that the Governor-General then gives a warrant to serve our country and our courts. And it's no disrespect, so I hope it isn't taken in that vein. But what I wanted to do is just to consolidate, as I said before, the mana of the Minister of Māori Development, the mana of our Māori Land Court judges, the importance of our whenua, and the mana of our whenua and how it's administered. And so that was the intention behind my supplementary order paper. And as I said before, if I have to withdraw what's currently on the table and come back to the House with an amended supplementary order paper, then I will do so. So the Minister might like to provide that clarity to the House, and then we can all move on with some, definitive direction about how we can address this particular issue. Kia ora tātou.
The Honourable to your